Hi, thank you for joining us today. Today we're talking about treaty investor visas, E-2 visas. E-2 visas are a unique animal in immigration. Essentially, they're State Department visas. So in that sense, they're a little bit different than domestic applications. E-2 visas are based upon treaty obligations that the United States has with the host country. There's a large list of countries whose nationals are eligible for these types of visas. Please see the link right here. Now, if you're a national of one of these countries, it is your treaty right as your host country in the United States. They have an obligation with each other, a reciprocal obligation with each other for their citizens, their nationals, to be able to apply for this type of visa if they qualify. The E-2 visa is a very flexible type of visa. The flexibility lies in its purpose, essentially. Consular officers are experts at adjudicating these visas. It is a State Department visa. Sometimes people apply inland in the U.S. with USCIS. They know this flexibility, but sometimes they apply it more rigidly, adherence to the underlying context of the visa. The Foreign Affairs Manual, it states, paraphrasing, the congressional intent of the treaty investor visa, although this classification mandates compliance with a lengthy list of requirements, many of these standards are subject to the exercise of a great amount of judgment and discretion. Again, the consular officer at the embassy, at the consulate, is an expert at adjudicating these standards and applying this discretion. One element of the visa may be strong and another might be weak, but the strength of that one can overcome the overall lack of sufficiency of one particular element or not. They have this discretion to do that. And the consular officers should remember that this is the basis of this classification, that these treaties were entered into to enhance and facilitate economic and commercial interaction between the United States and the host country. It is with this spirit in mind that consular officers should be adjudicating these types of visas. Now, the E-2 visa's got quite a lengthy list of requirements that have to be successfully shown in order to have an application approved. One of the most important ones is investment, the actual investment itself into the U.S. Now, investment can be broken down into generally three categories: source of the funds, whether the funds are at commercial risk to the markets, and substantiality of the investment. Source is simply that the government just wants to see that it's coming from a lawful source, that you just didn't find the money sitting in a duffel bag on the subway. You can prove that in a variety of ways: employment income, tax returns, pay slips, also sale of stocks, bonds, sale of assets, or one of the most popular ones is sale of real estate. You sell some real estate, the funds realized from the sale, that's your investment. The second component of investment is that the funds are at risk to the commercial markets. You can essentially do this in two ways. Either you spend all the money that's required to get your business operational. You've bought the goods, the inventory, you've set up the website, you paid for the marketing, you've signed the lease. Anything that needs to be done in order for the business to open its doors to be operational. You've spent the money. Your funds are at risk to the commercial market. If something goes wrong with the business, you could lose that money. The second way to have your funds at risk to the commercial markets is put the funds in escrow. As opposed to you having spent all that money, you can put the funds into an escrow account. The escrow agent, they have one instruction. Once the visa is issued, everything that needs to be paid for, the goods, the lease, the website developer, the marketing people, the inventory, all of that gets paid out immediately by the escrow agent as soon as the visa is approved. Now, the beauty of it is that, God forbid, the visa gets denied, that money comes back to the applicant. So that satisfies the at-risk element for the government. The money is out of your hands. Once the visa is approved, all of those things are paid for. If they deny it, then the money comes back to you. The government realizes that spending thousands of dollars on something that you're not entirely sure that's going to be approved, it's problematic for a lot of people. Using the escrow satisfies the at-risk element of the visa. The final element of the investment section is the substantiality exercise. Essentially, what this element of the regulation state is, basically the State Department is trying to assess whether or not the investor is unquestionably committed to the successful operation of the business. Quoting the Foreign Affairs Manual, it's intended to weed out risky undertakings and ensure that the investor is unquestionably committed to the successful operation of the business, opening the business and conducting commercial transactions. Since this is a subjective exercise, what the Foreign Affairs Manual gives the consular officer, it's called a proportionality test. Essentially, the proportionality test is, how much does it cost to get the business operational? How much does it cost to open your doors for business? If it's a small investment, $100,000, $200,000, generally they require all of that money to be committed at risk, escrow, or already spent. That gives a proportionality ratio of 1-to-1. If it's a more expensive business, say for $1 million, the consular officer would like to see a higher amount, maybe not the full $1 million, but something reasonable, maybe 200,000, maybe 250, something reasonable to show that the investor is unquestionably committed. He's committed $200,000, $250,000 to the acquisition of a $1 million business. He is committed to the successful operation of that business. That's not a 1-to-1 proportionality ratio. That's going to be a 1-to-4 or a 25%. If the more higher dollar value of the business, a proportionality ratio of that is acceptable. Essentially what they're trying to commit, again, substantiality. Are you committed to the successful operation of the business? Another key element of the E2 visa is called marginality. The E2 visa is designed in exchange for a treaty national being given a visa. Number one, they want to see that the funds are committed, the investment, that they've invested money. And the other key element is marginality. Is the business non-marginal? Marginality is a legal definition. Marginality means, is it going to make enough money to, number one, to support the investor and his family? And are they going to create American jobs? That's the key to any type of financial related immigration type of visa. The key is to create jobs, spur the American economy. Are you creating jobs for Americans? Now, the number of jobs created, it depends on the type of business. A small business may not create very many jobs, but if you're creating some jobs, that very well may be non-marginal. Larger business is obviously going to create more jobs. And essentially that's what that's designed for. It supports the investor, but it also creates American jobs. Hopefully you enjoyed that video and found it informative and maybe highlighted some of the complexities of the E2 visa. E2 visa is a wonderful tool for foreign nationals to be able to come to America and live and work here. Your spouse will be able to get an open work permit. Your children can go to school. As long as the business is operational and Americans are continue to be employed at the business, it's pretty much renewable indefinitely. It is a non-immigrant visa, so you still have to maintain ties to your home country. But as long as the business is operating, Americans are hired, it's pretty much renewable indefinitely. Thank you very much.